Eric Hunley has the whole monopoly. I don't know who that son of a bitch thinks he is.
Welcome to Laid Back Law with your favorite lawyers from around the interwebs.
No. Piers Morgan is doing the hide my boner lean. That's what he's doing. Look at him.
I think this is actually the first time that a billionaire cut safety standards, and it was the billionaire themselves that died.
And that's what made Poliere's, I don't even know how to pronounce this guy's name.
Poliere.
I'm board certified criminal trial law in Florida. I'm your man. Of course, you have to compensate me.
Discussing the most pressing of topics every Friday at noon Eastern Time.
I did this way before him. I had the big brain panel before Eric Hunley even existed.
Is it your testimony today that you personally witnessed President Joe Biden commit a crime?
I believe the fact that he was sitting with me while I was putting together a business
Did you
deal,
witness the president commit?
Well, I'm on the road, so welcome to another intro that we're probably not going to go over because that's a bit of an old subject. There is something in Congress to go over, but I probably won't talk about it here, and that's whether it's Congress or a nursery, because we had literally like a little high school exchange going between the females in Congress. Honestly, I don't know any other way to put it, but they were slamming insults like you can't see through your false eyelashes, you're a bleach blonde, blah 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 blah. Some really productive professional comments from both sides of the aisle. I'm not going to criticize one side or the other on this because they both look like idiots. And then a chairman of the committee going, I have hearing aids. I'm deaf. I don't know. What did everybody say? What am I doing? What am I doing here? Which I actually can kind of understand. And I am sympathetic to this gentleman. But welcome, everybody. We have a new panelist with us today. It's Alan Robert Shaw out of the UK, where I believe it is not only dark behind him, but going dark right now. I don't know.
No, it's still, we've got about another 4 hours of daylight. And I live right down in the southwest in the little bit that sticks out into the Atlantic. So I actually get about an hour's longer light than my London colleagues. It's very nice in Zooms, especially in winter, where they're all like looking miserable. And I'm going, hey, I've still got daylight. Although then I remember that I'm stuck on a Zoom with a load of lawyers from London. So it's like, I've got all this dialed daylight that I can't use.
There's no winter.
And then welcome to winter. I bet it's reversed in winter.
Oh yes, very much so.
Anyway, I brought Alan aboard because one of the hot topics from my other channel right now is body language statement analysis on Fiona Harvey, who is, I don't know how to explain it, but there's a very popular show called Baby Reindeer on Netflix out right now. And it has taken the world by storm, I think, more than anybody expected. I think it's one of those, it's almost like Tiger King in the level of how popular this thing is. But it's a story about a comedian who is being stalked by a female. The names are changed for the story. However, Netflix on the show says this is a true story. A Netflix producer went in front of, I believe it was Parliament, and said, this is a true story. And the person who is represented as Martha in Baby Reindeer is supposedly a woman named Fiona Harvey. And I say supposedly because she has come forward and done an interview on Piers Morgan. And throughout the interview, she essentially said that, yes, she's Fiona Harvey and didn't do all that, but no, I can't be Martha, but yes, I can be Martha, but no, I can't be Martha. So I'm actually very, very confused whether she is or is not. But I think that is a factor because her statements, being contradictory could be a factor. But one main element I want to go into is the question of defamation. And I believe she is going to go forward with legal action. Reason being, the Netflix special not only represented her in a specific way as a stalker, but made the specific allegations that she was convicted or pled guilty and was convicted of stalking and even served 8 months in prison or something of the sort. So that is a very specific claim. And I guess where I'm going is, even though technically speaking, there was another name being used, I think back to the Johnny Depp Amber Heard case, and Amber Heard did not use Johnny Depp's name, but Johnny Depp still prevailed in his defamation. So I'm sorry for the long-winded explanation. I just really wanted to catch everybody up on what is the case. I want to hand it over to great shirt, Phil, and welcome to Alan, and see if he has any immediate thoughts on, could there be a case for defamation in the UK? And I want all the US lawyers to jump in and say, well, here's how it works here versus there, or whatever.
Well, yeah, to put it very quickly, I mean, first of all, it would be a claim in England and Wales. We don't have a UK system here. We have there's a separate system for England and Wales, a separate system in Northern Ireland, and a separate system in Scotland. But yeah, a claim in England and Wales. I mean, to cut to the chase very quickly, she does have a fairly reasonable claim. I mean, if this was a client walking in off the street, I would say, right, bearing in mind what I know now, yes, you have a potential claim. There are a few hurdles, but they're not necessarily that hard to overcome. However, Netflix do have quite a good defense because their defense would be to show that, quotes, this was substantially true. Not necessarily that we've got every single thing right. Because the test over here is in every common law country is, will this statement or this publication lower somebody's reputation in the eyes of right-minded people? Okay, because the thing about defamation is it's about reputation, not character. It doesn't matter what you're really like, it's what people think you are like. So if people think less of you because of something, then that is potentially defamatory. There are a couple of hurdles to overcome. First of all, they didn't name her in the program. So this is what we call a special circumstances. It's sometimes called defamation by innuendo, which is slightly different to the American defamation by innuendo. But the question would be, would a substantial number of people realize that this was her? You know, there's that old joke about whenever you write a fictionalized version of somebody, and you to avoid defamation proceedings, you should always give them a really negative characteristic. Like the old joke was, you should always write that they're really terrible in bed, because then nobody goes, that's clearly me. That's obviously me. I recognize that it could happen to anybody. Conversation. So there's that. The other thing she has to show is that she has suffered, quotes, serious harm. A statement in England and Wales is not defamatory unless you can show it has either caused serious harm or would tend to cause serious harm. And you have to do that on evidence. We no longer have defamation per se here, where things are actionable per se. I mean, it used to be that England and Wales were notorious for being very claimant, or as you would say, plaintiff-friendly jurisdiction for defamation. And we got a lot of libel tourism, forum shopping. People would find an excuse to sue in England. And personally, I really liked that because I did lots of work for people in countries that, I had to get an atlas out to find. Post 2013, that has really changed. And now it's a lot easier to defend a defamation claim. However, in terms of evidencing loss and serious harm, there's a general thing called that if you are accused of a criminal offence that can attract a sentence of 12 months or more, that is held to be evidence that it would cause you serious harm. So the question here is, has she been accused of an offence that would attract a sentence? And yes, harassment and stalking would tick that box. The other thing is, it's also defamatory to say somebody has served a prison sentence and been convicted if they have not. Okay, so that's the problem for Netflix. I mean, the first of all is, they will argue and say, well, we never said it was her. And the thing to remember is, although now we all know who we're talking about through separate elements, through other interviews, when you sue for defamation on a statement, the court says, we have this single meaning rule, which has been challenged. But the basic thing is, what would your average person think this meant on just viewing the one thing? And how much extra information would they have? If you have to Google people, or if you have to search, then they say, well, no, because, you know, what would somebody just coming blind to this? I've stuck the TV on. Here's a television drama. They've not used people's real names. I don't know who they're talking about. You know, that would be the argument. They say, well, your average viewer isn't even going to know who this person is. They will no doubt say, well, no, everybody knows who she is now because of the interviews. A defense to that will be... Sorry?
Question on that point. Who's echoing me?
Is that me?
Phil? Okay, I don't know. I was echoing somewhere. Essentially, everybody figured out who she was. That's why she came forward. The quote, internet sleuths is what they like to call them. And they're saying Netflix is very irresponsible because they used actual tweets that she sent to the guy. So people just went really quickly, looked it up, and they said, oh, look at that. The actual tweet. Here's the person. Here's a picture of her. And boy, she looks a lot like the actress who was portraying the character. So they kind of painted a pretty easy little breadcrumb trail. I don't know if that's enough, but I did want to add in that fact.
That's a brilliant point, Eric. And this is something that will come into it, you see, because Netflix will argue nobody will know who she is. They will say, but anybody who did that research will know who she is. So that will actually, what might be the argument is, okay, in terms of what's the extent of the publication, which obviously goes to the level of damages, they will say, we won't look at what the viewing figures were for that program. We'll look at somehow trying to assess how many people would have done that extraneous research to track this person down. And it might be, well, 5 million people saw the program, but we reckon only 10,000 people would have actually gone further. And you try to put in evidence of this. It is really, really, really hard. Just as an aside, because I like to go off at tangents, a little trick for anybody suing a publication for defamation. We always used to do this, especially with newspapers. Ring up their advertising department and say, we would like to put an advert in of exactly the same size as the offending article. We want to put an advert in that's 5 column inches and this long on page 8 of the thing. How many people, though, would actually get to see that advert? And they'll say, oh, loads of people. Our newspaper sells 100,000 copies and every copy is read by 27 people in the family. Can you put that in an email, please? Yeah, sure. And then when you sue and you argue about publication and they say, no, nobody will have seen this article, you go, well, that's not what your marketing people said. So just remember that for future reference. It's a nice little way of showing publication. But that's going to be an issue for them here. How many people will have made the association and identified her? And so long as it's more than, a handful of people, that might be enough to get her across that hurdle. And she can say, well, people will recognize this is me. And what's the serious harm? Well, you have accused me of a criminal offense and said I was convicted of this offense, and I wasn't. So that was the starting position would be, well, that establishes serious harm. But it is a defense to say, okay, we didn't get everything right, but we got everything substantially right. And does the bit we got wrong make a difference? Will it make a difference to people to go, if they're going, oh my God, she's clearly some crazy stalker. Does it matter that she was convicted? Well, I didn't think she was crazy, but if the courts say that she was convicted, then that's enough for me. That, now I'm convinced. Or will people say it doesn't matter whether she was convicted or not? Because that, the fundamental allegation is this was somebody who was harassing and stalking somebody. And if they can show that, Netflix would argue and say it makes no difference that we got it wrong, assuming they have got it wrong on the conviction. And this is something that it would be very easy for her to prove that she hadn't been convicted. It can be quite hard to prove that somebody has been convicted because you'd have to troll newspaper reports. There's no real public database of whether somebody's been convicted or not. But what we can do in this country, we have something called the DBS service, the Disclosure and Barring Service. And they provide certificates. Say you're going for a job in a sensitive area or even a school, or you want to be a teacher. You would have to get a DBS certificate. And that will list whether you have ever been convicted of any offences. I mean, there are 3 different levels of DBS. The basic one is, have you ever been convicted? The second one is, have you been convicted? And we also take into account spent convictions and things that are normally expunged from records. And the third level is, here's all the intel we have on you, including whether the police suspect you of being an offender. But it'd be very easy for her to pay the sort of, £18, whatever it is now, and get a DBS certificate and say, I have never been convicted. And if she does, I know that she's spoken to Chris Dorr about this, who's an excellent barrister, much better than me. You should have got Chris on, really, because he's really good. But I know that she has been in touch with Chris Dorr. And obviously, barristers tend not to talk much about their own cases. And there's a culture that we tend not to talk about our own cases in this country. So he's been all he said is, there has been communication, but I'm not going to speak about it. But yeah, she's instructed counsel. It's probably worth sending what we call a letter before claim, just to sort of say, this is the defamation. What are you going to do about it? Now, it's whether Netflix stick to their guns or not. My guess is that Netflix have to stick to their guns. Now, it might be they would be willing to say, we'll offer a clarification. Dear public, in our series, we said that the person had been convicted. This was clearly fiction, and this is one of the bits that we added. I mean, the problem for Netflix is that they say at the beginning of the the drama, this is a true story, not this is inspired by real events or this is based on a true story. They specifically say this is a true story. Now, they do have a disclaimer in the end titles. So the question will be, how many people?
How many of us watch credits?
Well, yes, but in English defamation
and Netflix also has a built-in skipping function. Hold on, Netflix even worse, because they promote a behavior of binging. Their shows roll right into each other. And I know this because I'm in the end credits on a show, and I had to work to even see myself. I had to go, not hit the skip to the next show, and then go all the way through, and then finally I was like, pause. Oh, I mean, I had to work to actually see it. So I just want to
can I ask a question? I got a question about the Netflix thing. Eric and I were at dinner last night talking about this, and so even though I came in late to the discussion, I feel like I know what we're talking about. But the question that I've got is how did this get past the lawyers for Netflix? In other words, it's my understanding that they have legal teams that go over and scrutinize all these things well before they're broadcast or they're published or whatever. And I can't get my head wrapped around why the legal department would not have caught this before.
Well, they will have done that because I used to do a lot of it. I used to do what we call night lawyering, libel checking for some like newspapers over here. Now, there's a couple of things here. First of all, there's which jurisdiction are your lawyers familiar with, your defamation lawyers? Because obviously people have different thresholds in different countries, and Netflix show things differently. Now, I used to have to do this because obviously the newspapers, especially the online version, was available in different countries. So you had to have a sort of cursory knowledge of other countries' defamation rules. It will have been libel checked. However, all they would say is, this is potentially defamatory. You are accusing somebody of serious criminal behavior. But if they'd come back and said, yeah, but we can back it up, we are confident that we can show this is true, then, they will broadcast it. Also, you've got to look at the mere financial things here. An average defamation payout in this country, a high-end defamation payout, something like this, you're looking at probably about 80K, 90K in damages. You've got to weigh that against the cost of, the revenue, because we don't have the concept of punitive damages in this country. Damages are purely compensatory. In other words, it doesn't matter. It's just here's how much would it take to hypothetically put you back into the same position as if you've never been defamed. Now, I know it's a completely artificial thing, but it's the same when we do personal injury payouts. I mean, I'm sure most people would rather still have their arm than the payout, however big it was. But, people do take those into account. Now, in defamation, having said we don't have punitive damages, one thing we do have is aggravated damages. And that can be where somebody has cynically taken a calculated view that it was better to, it's a bit like unsafe at any speed and the Ford Pinto. It's cheaper to just pay out the compensation claims than it is to fix the problem. if people do that, sometimes courts can actually enhance the damages. We artificially pretend that it's not punitive damages. We just say it's purely compensatory, but you deserve more compensation because you have been very horribly treated by the cynical way they did the calculation that it was better to defame you and pay you off than to not broadcast the program. I mean, also we're getting to this silly issue of cost. Defamation costs in this country are horrendous. The rule
we have punitive damages. Let me interrupt. We have punitive damages in the United States, and it's for the purpose of deterring, this kind of egregious conduct. And I think it is pretty egregious to falsely claim that someone had committed or was convicted of a crime. And when you say it's a true story, that's what you're saying. And you may not be saying the words, but when you say it's a true story, you're saying that the facts that we are presenting in this story are true. And so I think in my view, it's fairly irresponsible, particularly of a big company like Netflix and all the attorneys that they have. And if I'm to understand that their legal department did in fact review it, and then they still let it pass, to me, that argues in favor of more punitive damages, because punitive damages are designed to deter egregious conduct, which I think this, in my view, clearly is. So, of course, Netflix is broadcast around the world. And as you point out, we have different laws in different countries. But the United States is still a big, big share of their market, right? And so they could conceivably get popped. And even if it's not something that would be actionable across the pond or elsewhere, even if it's actionable in the United States, that could be still very, very expensive for Netflix.
Absolutely. I mean, the thing here, of course, is that the English rule is that the loser pays the winner's costs. So the risk for
we need that. We need that rule in the United States. Absolutely, we need that rule.
Yeah, it can certainly. Oh, sorry, Dani. Yes.
Do you think, as a practical matter, that she'll actually be able to prove damages? I mean, based on everything that I've seen in her text message or in her tweets and everything else, the lady sounds like a whack job. And I wouldn't be hiring her anyway. And so I wonder how much of the damage is self-imposed here.
Well, that will be a big, that will be the argument. Because let's say that she can establish some sort of liability. Okay, yes, I was defamed. And, the fact that I was falsely accused of being sent to prison when I wasn't, that is defamatory. And the court says, okay, it is. But that has caused you some harm. But they will weigh it in the balance, because, like I say, it's about reputation, not character. She might be the nicest person in the world. She might be wonderful, but if people are already saying, well, just on the bits that hasn't been found to be defamatory, my opinion of her couldn't get any worse just by the fact that she was actually also convicted. Then,
and besides that, she's also allegedly stalking other reporters as well, and this pattern of behavior has been repeated now. So. She's not helping herself. If I were her attorney, I'd tell her to shut the hell up now.
No, I would. I would basically. I would basically. My advice would be: we'll zap off the letter before action, see what's coming back. We could issue the claim, but the risk is that it could be struck out at an early stage or summary judgment. We don't have any official anti-slap legislation here yet, but the courts, of their own volition, have affected. They're a lot more open to the concept of slaps now. So they might. I mean, in a case like this, where it's a private individual, they'll be less minded to find it as a slap. Before this happened, she wasn't a public figure. She's not a big, well-known name. So that would go into the mix where they'll say, well, no, this is a private individual who, on a national platform, an international platform, has been accused of very serious behavior, was not offered a right of reply or indeed consulted before we broadcast this to sort of get her version of it. I mean, that isn't definitive as to whether it used to be we had a thing called the Reynolds checklist, just to get technical, the Reynolds defense, which was a list of factors, offer the person a right of reply, get at least 2 sources, make sure, and if you did all that, then even if it turned out you've got it wrong, it did provide a defense. That defense has been specifically abolished now by statute, but even though the court said, and don't sneak the Reynolds defense back in through the back door by pretending it's a checklist. And we all went, okay, no. And now, of course, everybody goes, well, not trying to argue a Reynolds defense, but if we look at the factors, and that will go into the mix. Now, it's obviously different between a drama and, say, a factual news reportage, where you can say either offer somebody a chance to be on the program, or you can at the end of the news story say, we have contacted Mrs. So-and-so, and she says it's all lies and blah, blah, blah. Because then you've put their point of view across. It's harder in a drama. But the fact that they didn't even get any input from her will actually weigh in her favor when the court is deciding whether this is a slap or not. Personally, I don't think a court would find this is a slap. It may well be, though, that it gets struck out at an early stage. Because another thing, because we don't have juries in defamation trials anymore, the judge also can find matters of fact. So the first thing that you have in a defamation case usually is what we call a meaning hearing.
So you've gotten rid of defamation per se, but you also got rid of a jury trial, and now you're leaving it up to the judge.
Yeah,
I don't see a problem with that.
Great, yeah.
Speaking of, hold on. Speaking of judge, before the chat goes completely bonkers, I know that they're dying to hear about other possible defamation, like including the Trump case, but we've got a lot of hot topics there with Michael Cohen. Phil broke some news on that. Ian produced Ian shared a video yesterday that he went on that's warmly called the Dicks of Hazard. I don't know if everybody has seen that particular video, but I thought it was a very nice piece of art. Did you want to share your screen, Ian, if you get a chance? And I don't know if people saw that. In the middle of New York, a pretty famous artist, I guess, out of Staten Island, decided to express himself in a way by creating a bunch of, I'll say, phallic balloons, as in not just phallic, not resembling, but actually these appendages floating into the sky with many, many faces on them.
Oh, I gotta look that up.
Pointed out that in fact, they could be busted and not on speech grounds, which I think is a very interesting take on the situation. And I want to go over that and then shift into Michael Cohen. Phil's been covering that. And obviously,
what news did I break? Remind me.
The Michael Cohen perjury bit, and then Joe is still trying to get a gag order lifted before the trial's over.
Okay.
So a lot going on here. Actually, you know what? I'll just shift to Joe. What's going on with you, Joe? While we're finding the.
Oh, well, you want me to update you on my efforts to ungag Trump? Well, this week, New York decided that we don't really care about freedom of speech at all. We were strangled by, our application has been strangled by the First Department for the last 2 weeks. We had two things that were going on at the same time, which, even though they had identical relief and were due at the same time, were technically two different things. There's the Article 78 petition, which is basically like the petition is basically like a complaint. And then we had a motion for immediate relief. Now, New York recognizes that as two different vehicles. And even though the motion was primarily seeking the same remedy as the overall underlying complaint, those are two different things. They both were they both were listed as being returnable on May 6th. After we filed our reply, and there was a time for the adversaries, which is the district attorney's office, as well as Judge Merchan, to file opposition by April 29th. They did that. We had to file our reply by May 6th. We did that. They didn't want to accept our reply. I think I may have covered that last week, how we had to get a letter application. And then the clerk was supposed to tell us when this thing is marked final. Now, I was surprised when I went in there on May 6th and they said, we'll let you know when it's final. I was like, it's supposed to be final today. Like, what do you mean you'll let me know? When am I going to hear back from you on that? They said, oh, it should be pretty quick. And then at the end of the week last week, they said, well, by Monday, we should tell you what the final date will be. And Tuesday came, Wednesday. And we were like, they can sit us out here till July. I mean, make this moot and then say, sorry, it's moot now. So my lawyer, Ron Baruti, came up with the idea of filing an appeal to the Court of Appeals. and saying, look, every day my harms are refreshed anew. Because under Article 78 procedure, if you're denied and it's not a dispositive, meaning it's not ending the whole thing, there's still more going on, most of the times you cannot go up to the Court of Appeals. But if the nature of that denial and emotion is now putting it in a place where that if a dispositive answer later on is going to be deeply affected by that termination on the motion, then you can go to the Court of Appeals. So Ron Baruti spent a full day putting together papers to establish for the Court of Appeals that I'm being harmed every single day. So even if I were to get relief next week, 2 weeks from now, 3 weeks from now, whatever damages I'm suffering today, tomorrow, the day after that, will never be remedied at all by the court. So there's no way they can remedy it. Once it's gone, it's out. So that's why we need to go into the Court of Appeals right now, rather than having our application strangled by just delay in the first department. And the Court of Appeals was very quick. You had to submit it via email. If you don't upload to NICEF, and the court reviews your application as to what you want to upload and says, we'll approve this or we don't approve it. We submitted it in the morning, and they were back 4 hours later saying a judge reviewed your application and it's denied. There's nothing pending here before the Court of Appeals as of right now. So
I think Ian has the video ready, and we'll definitely get back to it. But I wanted to share this important moment. It is related to this trial and Joe and
no. So I mean, look, and let's face it. Pictures of floating dicks is far more entertaining than anything I can say. So
or any of us.
We're going through a global helium shortage right now. And in my mind, this is the perfect use of what little helium we have left.
Can you guys see this? I'm sorry.
We see it. Yeah. 99.
All right. Donald Trump's biggest fan released funny-shaped balloons in New York City today. Yes, the balloons had on them photos of Jack Smith, Judge Goron, and Alvin Bragg. The question I got asked was, is this illegal? Jack and Alvin and company arguing that they got defamed isn't going to fly. Because they're public figures who have a higher burden of proof, and the fan has the First Amendment on his side. But believe it or not, NYC has a law that says you cannot release 10 or more helium-filled balloons within a 24-hour period in the city. So yeah, the fines the fan is going to have to pay are up in the air, but he's not going to jail or anything. Donald Trump's.
Here's the thing, guys. Here's the thing.
Oh, that was cute.
That's awesome. It's awesome, Ian. Everything you do is gold. Great. Everything you do is gold.
Oh, thank you so much.
My question is, if they get hit with a fine? Yeah, first of all, this is how I could see it going back and forth. Number one, I would see that I would try and defend that and say, this is not, you might have a general ordinance against people just randomly allowing balloons to flow up in the sky and letting thousands of balloons go up. In this context, this is an expression of speech rather than just waste. And under the First Amendment that you can't just restrict them from engaging in that. So to the extent it would be applied here. On the other hand, I could see New York saying, A, we don't really care about freedom of speech, as we told Joe went in his application, and B, this is damage to the climate. So
no, it's a safety issue, Joe. There's helicopters that fly around New York. They have a problem.
Oh, that's
there's also point. There's issues with traffic.
Counter.
There's issues with there's actual.
Wait, hold on a second.
Actual safety hazards. Chicago had a similar, wasn't it Chicago where they released a gazillion balloons as part of this celebration of cancer survivorship or something. Anyway, it clogged up drains and there were all sorts of problems. So I mean, the city can argue
a safety issue would be
for
great.
safety reasons. So
yeah, that's a great point. I hadn't thought of. Thank you.
You can see a sea turtle with a straw in its nose. Balloon comes down, gets that, it inhales the helium, tries to talk to another sea turtle, high-pitched squeal, the other sea turtle starts laughing and drowns. I mean, this is terrible for the environment.
It is.
You're used to now. That's all I can imagine. Thanks.
Right. So anyway, I guess we lost our host here. So I'll just wrap up on this. With respect to my application, which is that we did hear back from them yesterday, informing us that we're supposed to be marked final as of May 22nd. They don't let me know whether or not I have oral arguments. We have to submit an application to be orally heard, and we'll let you know what the I'll let you know how that goes as far as whether or not we get to argue. But if you're interested in supporting this, and the arguments that we make are very, very different from the arguments that Trump made. Trump lost this week. His application was denied by the First Department, even though his was well behind mine on the timeline. But I guess his certainly had a great deal more publicity, which is probably why they felt an urgency to get a dispositive response to him. He lost. His arguments were rooted really in a claim that, well, I'm a GOP presumptive candidate, and this is all political speech. And that's nice as far as making an argument on behalf of himself. There's no yardstick really on, it's a very difficult yardstick. It's very amorphous. And I'm sure the left will call it not political speech. And they'll say, that's not really relevant here. But my arguments are rooted in the fact that the decisions that are underlying their finding of issuing a gag mean exactly the opposite, 180 degrees the opposite as to how they were used by the DC Circuit Court, how they were used by Judge Merchan, and they've been Frankensteined. They've literally been Frankenstein. These decisions, which basically say we should never, ever, ever, ever gag someone. And it's like they hacked these decisions up and just completely morphed what they said and took this body part, that body part, and all of a sudden created this brand new monster, which is allowed to gag whatever it wants. And the original bodies were all saying, no, never, ever, 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 unless it's like basically, the world is about to end, then you can infringe on First Amendment rights or someone's constitution. Really, it's when someone's constitutional rights are being destroyed, not hurt, but destroyed by the free exercise, the unfettered exercise of First Amendment rights. Then we can say, you know what? We're not going to cut off your First Amendment rights, but you might put some little guardrails around to make sure it's not completely destroying someone else's constitutional right. That's the only time that the Supreme Court has ever allowed for it, which is why I'm positive if these people who authored the original decisions that were cited by Judge Merchan and by the DC Circuit Court, the authors of Landmark Communications versus Virginia, the authors of Shepard v. Maxwell, the authors of Nebraska Press Association versus Stewart, which these are the three principal cases that were relied upon. And these cases were all decided between 1966 and 1978. I'm sure the authors are no longer here, but their bodies are rolling around in their crypts because, my God, their whole agenda was we can never ever do this, never ever, and they became the justification for issuing a gag order. It's shocking. It's really shocking.
Joe, I was going to ask you something, and pardon me if it's a little pedestrian, but it kind of is related to this. There's a big, lot of posts today on X about Donald Trump falling asleep in court. Mm-hmm. And I was going to say, what's your thought on that? Have you seen that? My response to it actually is kind of maybe surprising to some people, and that is, I fully expect it. When your livelihood, when your life is on the line, you're up late at night, you're a 70-something-year-old person. I've been in situations, even as the lawyer, and I haven't fallen asleep yet, but I've gotten to situations where it's a little bit sleepy time because we're talking about introduction of documents and evidence concerning maintaining documents, really, really boring stuff. So I basically said, you know what? I totally get it. Not defending Trump necessarily, but just saying I would do the same thing. If I was in court close to 8 hours a day and there's a lot of boring stuff going on, it's not like on the movies, I'd do the same thing. What do you think about that?
Yeah, this is all. It's part of the framing that's designed to make him look old and frail. That's essentially what that's why they're doing that. Defendants all the time will pass out in court, and that doesn't. But I have no doubt that the objective there is to basically try to basically scream that he's not fit for the job of presidency, and that's why they're reporting on that. That's why there's I've seen multiple reports now where he's allegedly got bodily emissions of one sort or another, and that's also designed to basically say he's not fit to be president. That's why they're doing that. So, which is
in fairness, Joe, it's not like there aren't memes about another presidential figure pooping his pants and everything else. So, I mean, if I'm being honest, maybe that particular line of attack is being used
to try and
both
refute
sides.
that. Oh, 100%. That I think that this way.
Yeah,
they can
but
try
some
to
attacks are a
offset.
little more legitimate than others. When you have a world leader walking around and doesn't know where he actually is, and you have actual like credible allegations of poopy pants, there's a huge difference between that and a guy who's dozing off after an 8-hour court trial.
I doze off in court.
Where he's
I mean,
literally
it's
not
boring.
allowed to say much.
Poopy
So,
pants.
But it all depends on who's saying it. If you're on a left-wing podcast, they'll be saying it about the other guy. If you're on a right-wing podcast, they'll be saying about your guy.
And that's because they want the public dialogue to arm. I think it's really that they want to arm their followers with something to respond to all the claims about how Biden is too old to be fit to be president, especially since you had that report that came out which said he's not going to be charged with obstruction because he's too old to be charged. The left knows that this is a really difficult thing for them to overcome this problem, as far as the fact that he's ancient, that that our sitting president is, he's basically the crypt keeper. So
I mean, we prosecute Nazi war criminals that are 100 years old when we find them.
One thing I wanted to ask the panel. Joe Biden has just exercised executive privilege over the recordings of his interview, right?
Yeah.
But my question to you guys is that how could you? All right, so if the transcripts weren't out there, then maybe I would see how you can make the argument for executive privilege because the content isn't out, but the transcripts are already out there. So what executive privilege could you be asserting for content that's already out? You understand what I'm saying? It's not like the content is what you're trying to, because that's what executive privilege is. I don't want people to know what
I missed this story. Can you cover this? Can you explain what he's asserting executive privilege over and his basis for it?
All right, so Joe Biden, remember Joe Biden had the interview with the special counsel about the documents case. They said they're not going to charge him because he is so, an old man.
Old
he can't
and
really know.
incompetent.
So he's this is.
So there are two pieces that are coming out. First, it was the transcripts of that meeting that came out. And that's what everybody went over for. Okay, he's a bad old man. But they recorded the whole thing. So Joe Biden didn't exert executive privilege over the transcripts, the content of what was said. But now the recording was supposed to come out, and he exerted executive privilege over the recording. I don't want people to see what I said. So my argument is that doesn't make any sense because executive privilege covers the contents of the communications, right?
Well,
if the contents of the communications are out, then why wouldn't you just let the recording out? Because obviously the recording makes them look bad. Go ahead.
Because Nate, it's how he said it. He's obviously terrified because if he's meandering so completely and there's crazy pauses and he seems completely befuddled when he's saying it, that's far worse than just the text in a transcript.
I understand that. But I'm asking the legal distinction between the recording and the transcript, because attorney-client privilege, for instance, if we write it down, as soon as you get to understand the contents of what was being said, that privilege is gone for a third party. In this instance, the context is out there. Literally, the transcript is out there. So I don't understand how he could assert executive privilege for conversations that have already been leaked to third parties. Am I making any sense?
It makes sense. What you're saying makes sense, but you're talking to a panel of competent lawyers who can all understand.
Hey, speak for yourself.
The concept of lawyering
yeah,
being
exactly.
used for political means, and that's what this is.
As the non-lawyer.
I mean, I think that's a political maneuver to try and stall the ability for the public to hear and hope that gets past the election. I think that's. Is there an
argument though that actually seeing the video context will harm him more? Is something that should be done in private? There's an argument about testifying before Congress, in front of everyone, and also behind closed doors. Transcripts are often released, but much of the time they're videoed behind closed doors and they're never released.
I would counter that. I would counter that, Ian, by saying the reason why that's what you're describing is different. A critical distinction there is when someone says someone doesn't know what's going to happen in the future. So they might say, I don't know what questions are going to be asked or how things are going to come out. So that's why I'll only answer these questions behind closed doors. And then they might decide after everything's said and done, there's a difference between prior speech restraint versus post speech. So there, the person's trying to protect, what may happen. No one knows what's going to happen, during a 3-hour interview that has yet to occur. But in this context, I think Nate's point is correct, that if the whole point is to protect the institution, not the institution of the presidency, but some sort of, secrets from coming out, well, those secrets have already been revealed via the transcript, and the nature as to how they were communicated cannot possibly, or at least, it's difficult to understand a logical argument as to how there's greater exposure of that content simply by hearing him express it rather than the transcript that was recorded therefrom. So
yeah, it's like me going to court, and it's like if you have just a regular attorney-client privilege, and let's say the privilege was let out, third parties heard it. It was a transcript, everybody saw it. Well, then but then if the recording is out there, I don't think I'd be able to exert privilege over the recording because the content is already out there in the transcript. Does that's kind of what I'm saying? He's arguing form instead of substance, and I think the privilege covers the substance.
The cow's out of the barn. The cow's out of the barn already. So
it's the message, not the medium. I mean, that's the rule we have here.
Yeah,
is that once you've waived privilege in the core information, it doesn't matter whether it was an audio recording, a video recording, somebody had done it with finger puppets. It's still, it's the information you are protecting.
Yeah, that's precisely right, Alan. Are you guys reading any of the transcripts or reviewing how some of this testimony is coming out? Or I'm curious, are you relying on reports from media? Like, how if at all are you guys trying to follow this trial?
You talk about
it sucks, but you can't do this by watching somebody live tweeting. You just can't get the full flavor. It's really, really frustrating and pisses me off because I like to watch and hear every little thing, because there are things that we as attorneys might pick up on and notice that maybe the average person who's not a lawyer might not. So it's really helpful to be able to see and hear. But they want to release the transcript at the end of the come on, who's going to sit there and read a transcript and try to go only on CNN they go back and they use those transcripts to do dramatic readings. But that's
I do dramatic readings. I do on my show dramatic readings. I'll wait a minute. I want to invite all of you on Saturday night. I'm going to be doing.
Anyone else find this incredible? This is a U.S. president, and they're not live streaming this.
I know.
So
I'm watching the Chad Daybell trial, and I'm streaming the Chad Daybell trial. And
you are 100% correct.
New York doesn't stream.
This is insane. This is our president. We voted for him. He works for us. Okay. If there's any legal means to hold him accountable for anything, it should be us, the people who are watching this.
You are 100% correct in that. This is the one area that I'll defend Judge Merchan at all.
Fight.
I mean, I'm suing Judge Merchan, but this is the one area that I will defend him, which is that New York Civil Right Law 52 expressly prohibits cameras in the courtroom.
Yes.
In order for Judge Merchan to get around that he would have to leap through hurdles to get, he could issue. Do I think he should have? Obviously. Yes, no, and look, I'm all for transparency. I'm a firm believer that 60 to 70% of America's problems, 60 to 70% of America's problems across all stratospheres would be gone if we had greater transparency with respect to every one of our institutions. I'm talking about our court. We've seen how it's been effective with respect to the police. I'm talking about with respect to our court systems, with respect to our health systems, with respect to our educational systems, that all the things that people are like, we don't know what's happening there. And the more we see, whenever the little bit of the veil gets pulled back, we see it's gross and disgusting and corrupt and terrible. And that's why if we had access, or we talk about our elections. If you had
mean a public trial, like something that our forefathers maybe would have,
obviously,
I don't know, thought this through and included in a really special document.
So basically, the only reason that we don't have a trial that we can watch is because the judge is lazy and didn't want to jump through hoops.
Well, I mean,
not.
I'm a sitting member of the New York Bar.
I'm
a sitting member of the New York Bar, and under the New York Bar rules, and as I understand them, it's considered an ethical violation for me to ever challenge the corruption or anything with respect to our judiciary. I'm just sharing that as a legal matter, and I'm going to tell you all that I believe our New York judiciary is beyond reproach. So,
well, I agree
Well,
with
I'm not
Joe,
a member
but
of the New York bar, and I think he sucks.
But I gotta say this: it all becomes the rule for everybody. If they started, the argument from the other side is going to be, if we televise this trial, then every other trial that we didn't televise can have a beef and say, hey, why did you do it to us? What makes him so special? Now I do understand.
We can have
make it universally
so,
open and move on.
I agree. I think it should be, but I'm just saying I know what the argument.
Nate, we can have this rule, okay? No cameras in the courtroom except when there's a president on trial. How about that?
Yeah, this is special rules for kings and queens. I agree. Hey, that may work, but I don't think that's the system that we have. You know, everyone is treated the same.
Here's what
I agree that you don't have it, but it sucks.
I will say this is completely inexcusable. The completely inexcusable part of this is there's no reason that you couldn't that people cannot access it even if they go there. I mean, this doesn't make any sense. The federal court, you all know, we all know, we complain frequently about the fact that our federal courts do not allow cameras in the courtroom. What they do, however, even in New York, is if you go to the courtroom, any person, any time of the day, while a trial is going on, can go into a federal courthouse and say, I want to watch this trial. And from my experience, at least here in Southern District of New York, they will create viewing rooms. And if a viewing room gets overcrowded, they will create a second viewing room where they'll put up a big screen TV with massive speakers that the entire room can hear. And you sit there and you can watch. Now, the screen is like, everyone on the screen looks like 1/10 the size of what you or I look like right now. But at least you can watch it and you can hear it as it's ongoing. With this particular trial, there is fewer than 180 people who get to watch it because they have a seating capacity in the courtroom of 57 or 67 people, and then they have one viewing room of 112. And when that viewing room is full, boom, no one else is getting in there. That is, to me, asinine. That is insane. When they know that thousands of people want to come in and watch this trial, that they can't set up at least viewing rooms. Now, I agree with everything you're saying. No one should take this as me saying that this should not be published to the world. You should be able to sit. You should be able to sit in Cancun or in Burma or sit in Europe and watch this trial, because this is arguably the most significant criminal trial in American history. And the fact that Americans are being kept from watching this, to me, is outrageous. Don't take what I was saying. I was simply saying I don't look at Judge Merchan on this particular issue as being as something I would sue him for. Let's put it that way. I'm simply saying, but I do think the fact that people are not able to get into the courtroom and we can't even keep up with what's happening in federal courthouses, to me, that's inexcusable. That's something, I'll tell you right now, if I was not already suing Judge Merchan for that, I would be suing on this. I don't have enough hours in the day. But the fact that people can't get in and see
on
it.
the rule.
Yeah,
it makes me feel a lot better to know that it's universally.
It's the law.
That's why I was saying that. That wasn't.
Yeah,
it wasn't something that Merchan said, I'm not letting this case go. That was the default that New York was starting with automatically. That's why I was sharing that perspective.
I think.
And it doesn't. One thing, I think this rule doesn't protect any defendants or anything. It protects the court. It protects those judges from these bad. It protects them from being judged like, oh, this is bad. And that's what they're protecting. That's the only reason. But that's why I like places like Georgia and Florida with the sunshine laws, right? Everything is on camera. You can see everything, and you can put people's things to the fire. And it's like what Danny said. If it's about public trials and public access, this is how you stop public access, because it forces us to get a filter through the media. The liberal media is telling us Trump is sleeping, Trump is poopy pants, Trump is this, instead of you watching it. Remember with Rittenhouse. We all watched Rittenhouse, and everybody who watched that trial came out with everybody who watched Johnny Depp came out with a different answer, because you could see it for yourself.
Well, this is, do you remember the Kennedy-Nixon debate that everybody says that was, when Nixon had the flu and, was all sweaty? What's interesting, people say that lost him the election, but when they reviewed people who just listened on the radio, they thought Nixon had won the debate. Yeah. Now, obviously, coming from here, because we generally do not televise court proceedings at all here. And the transcript point that you're raising, that's a good one, because this crops up a lot in appeals, where you will argue about what happened in court, and especially where it's something either about witness demeanor or if you're complaining about a judge. If you're saying the judge was overly aggressive, descended to... The Court of Appeal has said it is difficult to do this from transcripts. I mean, they always say we'll never interfere with any findings of fact about witnesses because it doesn't matter what the transcript
Same
says.
here.
We weren't here.
Same here.
We couldn't see the body language. We couldn't see the demeanor. But it is a big issue. We are told that if we have a problem with a judge, say intervening or being overly aggressive, we need to, first of all, raise it and get on the transcript. Well, you know, Your Honor has just said this and you were very loud, or you were very this, or you've just rolled your eyes, or you have touched it. You know, you need to get it on the record somehow, because otherwise, as you'll know...
And this comes back to exactly what Phil was saying. This comes back to like, you need to see it. And also what Nate was saying as far as the depth be heard. There's a lot of times when you're seeing things that we as humans learn to filter out what is truth from fiction by actually seeing it. I'll respectfully submit to you that when Johnny's telling his story over about the fight where his finger is sliced off, he's telling it over, and as he says, you know, she throws a bottle at me and you miss, and he head jerks as if because he's remembering it in his brain. He's reliving it in his brain, and his head instinctively like moves like the way it likely moved, and that makes for compelling testimony. Contrast that with Amber Heard, who when she's talking about it, that same incident, she's like, and then he's pulling my hair, and that didn't ring true at all. And people might not realize why it ring true or it didn't. I respectfully submit the reason she didn't seem true is because if her hair was being pulled and she's reliving it as she's telling it, she would have said it as he's pulling my hair, her head jerking backward. She wouldn't be making the hand motion that everyone else would see. She'd be reliving it and her head would be jerking backward. These are things that we intuitively pick up on when someone's telling a story of this is truth, this is BS. And when you get just a transcript, you get zero of that. And the same way when you see a text message, that you can read something in a text message and have zero clue if the person is being a jackass and a jerk or making a joke or and you're like, wait, do you mean that seriously? Are you laughing? Like, I don't even know. It's the same thing on the transcript. You don't know the tone. You don't know how it lands. You don't know it has the impact on the room. If he says something in a funny way and the entire room laughs, that has an impact on the jury. That has a tremendous impact on the jury that we watching it have zero impact from that.
But that goes to the point of legitimacy, because that's all the powers that the court holds at all. Okay. That's what, to Nate's point, it's the only thing I care about at this point. When you're more open, it adds legitimacy to your court. And if you're more open and it takes away from your legitimacy, well, then maybe you shouldn't be seen as a legitimate body.
Yeah.
That's it.
Yeah.
That's it.
Yeah.
That's the problem right there. And that's why it's in our Constitution the way that it's written. We have the right to it. They need to open them up. That's my opinion.
That being
Totally
said,
agree. I think we're in a heated agreement on this whole subject universally. So let's shift. I know that Phil Holloway
before you shift. Okay, go ahead. You do you.
Go ahead, Joe.
No.
Go, Joe. Go.
Did I hear my name taken in
It's
vain?
about the same trial, Phil. It's the same trial.
I know. No, I was really good. I was going to.
Cohen.
No, well, I want to just stick on the whole credibility issue and ask that those of you who have been hearing about how Michael Cohen has been decimated, like your thoughts as to why it is that perhaps the left seems to be freaking out that this case is going up in flames. And I'm wondering if, what you guys have seen, whether you think, that this case is in trouble. But this is Eric's show, and I don't want to.
It's a great segue into what I'm.
Yeah, I think that's what Eric was segueing to. You did it, Joe.
Thank you, Joe.
For you, Eric.
Okay.
Please, I'm going to just mute.
All right. So
hold on. Phil's got props.
Looks like Eric has added one of my tabs
to
the
make that full screen.
All right. So what this is, I'll set this up. This is, I'm going to play a little bit of the live stream that I did on Inside the Law the other day. Not because it's my show, but that's because it's where I know this video exists.
Please make it full screen, Phil.
Oh, all right. So let's see here.
That one. There you go.
Yeah. All right.
Thank you.
So this is this gentleman seated here. It's in my Twitter feed. This is Mr. Costello, who was the lawyer that represented Michael Cohen. a number of years ago. I want to say it was like around 2017, 2018 timeframe. And he was relieved of his attorney-client, obligations to keep his mouth shut and all this. His attorney-client privilege was waived by Michael Cohen. And so he's about to tell you how he went and talked to what he said to the Senate or House of Representatives, a congressional committee the other day. And then after this, I want to talk about something he said yesterday. So let me just play this real quick.
At the request of the U.S. Attorney's Office for the Southern District of New York. The reason was Michael Cohen had pled guilty to 8 felony counts in the Southern District and was seeking to lessen his sentence. And he thought he could be clever by going into the U.S. Attorney's Office and lying about cooperation. Michael Cohen went to the U.S. Attorney's Office and accused Rudy Giuliani and myself of conspiring to obstruct justice by tampering with a witness, namely Michael Cohen. The story, which they were floating at the time and his lawyers put out in the various newspapers, was that we had dangled a pardon under Michael Cohen's nose in order to keep him quiet so that he wouldn't testify against Donald Trump. When I received the call from the U.S. Attorney's Office saying, Bob, we'd like to talk to you about your representation of Michael Cohen, I said to them, can I presume that you guys are sitting there with a copy of the waiver of the attorney-client privilege? They said, you presume correctly. I told them to scan it over to me, and once I received it, I'd be delighted to talk to them. And I did. I went down to 1 St. Andrews Plaza with a lawyer who had been the chief of the criminal division when I was deputy chief, Tom Fitzpatrick. And on the way into the office, he said to me, Bob, aren't you nervous? I said, what for? I'm going to tell the truth, and I have documentary evidence that corroborates me 6 ways from Sunday. I said, there's nothing to be nervous about. And in fact, I said, I'll bet you $10 I'll have these people laughing within 15 minutes. I won the bet. I went up and I sat with 2 assistant U.S. attorneys, Tom McKay and Nick Rose, as well as 2 FBI agents whose names, unfortunately, I don't remember. We had a grand old time. I explained our entire history with Michael Cohen through emails and text messages. I explained the many, many lies that Michael Cohen told us. Most especially, I told them that when we first met Michael Cohen in April of 2018, keeping in mind now that I read Michael Cohen's testimony from yesterday's trial in New York on the way down on the train, and virtually every statement he made about me was another lie, a lie that can be proven not just by me denying it, but by myself, Jeff Citron, or Rudy Giuliani, or emails or text messages.
All right. So, okay. So, we went on to talk about other things, but that was our first look at Cohen's former lawyer. And by the way, it's a little bit dark in here for everybody who's looking. I'm in a hotel room and the light really sucks. I'm sorry. But you don't really want to see my face anyway. He's saying that he is aware, this man is Michael Cohen's lawyer, and he's aware that Michael Cohen lied to the Trump jury in this very trial. And my, lawyer hat and alarms start flashing, and I'm thinking, all right, if I'm Donald Trump's lawyer, I want this man to come testify in my trial. So the next day, apparently, or maybe the day after that, yesterday, in any event, he goes on Fox News, and I was driving to the airport, and I pulled over to listen to this interview because I couldn't concentrate on driving and listen to his interview for like 10 or 12 minutes. He explained on Fox News a lot more. And he is 100% certain that Cohen lied about all kinds of things in this trial. He's willing to testify. He expects that he's going to testify. Was my takeaway from it. He says he hadn't received a subpoena, which tells me he would testify voluntarily if need be. And so this is what I'm waiting for to hit next, because, we all know that there's a number of ways that you can impeach the credibility of witnesses. They've spent the last couple of days demolishing this Michael Cohen. They've used the multitude of prior inconsistent statements. They've shown that he has this extreme bias. They got him to admit, for hell's sake, that he wants to see Trump in jail. And he admitted that at least in part, the indictment is because of him. and that he hates the man and he wants him in jail. He even admitted that he was pissed off that Donald Trump didn't bring him to DC and make him something like Attorney General. So we've got his bias that has been laid bare. We've got the prior inconsistent statements. We've got the felony convictions, and we have the character for truthfulness. And now we're going to have potentially another witness who can impeach Michael Cohen by direct contradiction. And he says he's got the receipts. He says he's got mountains of emails and other things. And in the interview with Fox News, he went further. And one of the things that he said yesterday that was stunning to me, and I've always said this case is fundamentally unfair. It's a due process violation. But he told me that because he testified to the jury, this lawyer did, all right, Costello. And he said that when he went in and talked to this grand jury, the one that indicted Trump for the case he's on right now, he took with him actual, reams of paper, documentary proof that's exculpatory. We call that in the United States Brady material. It's things that prosecutors are constitutionally obligated to hand to the defense. And what it was all of Michael Cohen's stuff where he says, I have nothing on Donald Trump and other things. And the prosecutor in the grand jury room refused to put it in because he said it's hearsay. Well, hell, hearsay is admissible in a grand jury. We all know that. Yeah. And even so, it's a business record. So there's a million reasons why that should have been part of the case. He says that he told the grand jury, despite the fact that the documents weren't in, he said to the grand jury, you guys should request this because it's highly relevant to the decision you're going to make. But nevertheless, prosecutors drive that train. But this man, it sheds light on the shenanigans that took place in that grand jury room where lots of Brady material never saw the light of day. And this jury needs to see it. This jury needs to hear from this man so that this jury, if they're not convinced yet, if they hate Trump so much that they're not quite convinced that Michael Cohen can't ever be believed under any circumstances, they need to bring this man to court and have him testify to prove it. My only concern is that maybe the judge won't allow that to happen. I certainly hope that's not the case, but nevertheless, we might be up for some interesting testimony in coming days.
Well, why would you let it happen? Because it's too late of a notice?
Can I just ask a question?
Let's get Alan in here. Yeah, let's get Alan in here because he had a question real quick.
Yeah, no, just from a sort of across the pond perspective, it's interesting how far you can go to impeach a witness, because over here the rules are, say you've got prior inconsistent statement, you can put to somebody, you are lying about this. No, I'm not. Then you can sort of say, well, here's the statement. But there's very strict limits on how far you can push that, because the argument is, well, look, we're not going to have a series of mini trials about each witness as to how credible they are. The jury can make their own assessment as to how credible they are. So, I mean, we have the same, what you call Brady material, we call unused material, which is really annoying because criminal practitioners on legal aid, you don't get paid for reading the unused, which is really annoying because that's often where the defense actually is, the 20,000 pages. But I'm just curious as to how far you can actually go to impeach, because over here, all you could say is, actually, Mr. Cohen, you're not telling the truth, are you? Yes, I am. Well, previously you said this.
We can go quite a ways. And with Cohen, there's a lot of material to work with.
Yeah, in fact, when you say a lot of materials to work with, one of the things they did was they played clips of him from his show where he's basically screaming, I'm going to get Donald Trump thrown in jail. That guy belongs in jail forever. And he's screaming kind of like me on steroids, but he's very aggressive about how he wants to get Donald Trump thrown in jail. When you throw that in context with what Phil just brought up with Costello, when this guy is at the end of his rope, he described him as being virtually self-delete territory, and that his counsel is saying to him, if you have anything on Trump, tell me what it is, and I can have this whole thing going away by the end of the week. And he's like, I got nothing, while freaking out that he can't. He's obviously racking his brain as much as possible. He even comes up with something. He's like, well, there's some money missing from the Trump organization. Great. Is that related to Trump? No. Well, that's not usable. He's obviously going through his brain, trying to figure out anything that Trump did wrong and still can't come up with anything. And now all of a sudden he's remembering some conversation that he recorded that supposedly shows that Trump is doing something illicit, I guess, under the advice of his lawyers, because his lawyers were refuting him. He was like, we pay cash. And like, as far as how that whole transaction went down, it was under the auspices of his counsel. But that he was in that circumstance and could not come up with anything is indicative of the fact that now this guy who's an admitted perjurer.
Hey, Joe, on that, let me interrupt on that point. And I want to see a show of hands here on the panel real quick. Raise your hand if you believe or have heard that Michael Cohen was convicted of perjury. Okay,
or at least
that's almost
admitted to
everybody.
It wasn't convicted. I mean, it was that he was admitted in that.
Admitted, yeah.
But he's not. He's actually not been convicted of perjury. And there's an interesting story. I told this to Eric last night. I've heard he was convicted of perjury. I know others have heard he was convicted of perjury. Judge Engeron, in his civil order, wrote that Michael Cohen had been convicted of perjury. And it's been reported on CNN and elsewhere that he was convicted of perjury. And so I had a good faith belief for believing this. So a few weeks ago, I made a tweet in which I referenced that he was a convicted perjurer and essentially that the state's case is built around that. And I tagged him. I tagged Michael Cohen. Well, he quote tweeted me and basically, and he says, that's obvious. He said another MAGA asshole is what he called me, saying things that aren't true. And, he says, I've never been convicted of perjury. And then he threatens me with an ethics complaint. And this is kind of like our discussion earlier about defamation, but it occurs to me that, well, I had a good faith basis for saying it. I'm not worried about a bar complaint from, of all people, Michael Cohen, but he's in this trial admitting that he has lied under oath. He went before Engeron and admitted that he committed perjury when he did his guilty plea in federal court. He said that when he raised his right hand, swore to tell the truth, in the guilty plea hearing related to his federal convictions, he said that he lied under oath then. So maybe he's not a convicted perjurer, but he's an admitted perjurer,
Yeah. That's why I actually use that term, admitted perjurer.
I do want to answer Alan's question now, because I think his point was astute. Yes, you can't have many trials. So if Michael Cohen has lied about one particular thing that's not material to the case, and he's lied, you can ask him about it. Hey, isn't it true when you said this? But you're stuck with the answer. Like if he says no, you're stuck with the answer at that particular point.
That's the same rule here.
But if it's material to the course of action, then you can go in, but did you lie about this? No, then you can go into it. And that's what you have rebuttal witnesses for. So if he does lie about something, I don't know if remember Fannie Willis, when they had the rebuttal witnesses try to come on and prove that she lied about the other attorney lied about other things. And they were like, no, he can't, we're not going to have a trial within a trial. He can't testify to those other things unless they're material to this trial. So that's kind of the way it works.
Cheers for that, Nate, because that's really interesting, because that's very much the rule here. I mean, you could put in you could say, isn't it true that on a previous occasion you said you want to see this person, go to prison, just to show that bias. We also have a standard direction here called the Lucas direction, where if somebody is suspected of lying, and especially if somebody has admitted to lying, and especially perjury, the direction is, well, members of the jury, although you can take that into account, you must bear in mind people lie for lots of reasons: to bolster a good case foolishly, to avoid embarrassment, to cover up disreputable behavior. You will assess that, but it's not the old rule, the old Roman law rule that false in one thing, false in everything, so everything became inadmissible. So is that a similar, will they make similar arguments in this case, do you think, saying, well, look, yes, he's admitted lying, however, he's explained why he lied, and therefore his testimony now you can...
That's the thing, though. His
we
lawyers
cut for
got
a second
him.
to Danny.
Yeah.
We cut to Danny.
Go ahead, Danny.
Thank you.
Action.
Props. I
I'm
love
so
it.
sorry.
Props.
I'll be very, very brief. I just wanted to give a quick update. So I'm covering the Chad Daybell trial right now on our stream, and we're on day 25. The state just rested, and right after they rested, and there was a motion for a directed verdict that was denied. the judge brought to everyone's attention, hey, by the way, your amended complaint, your amended indictment puts the wrong date of the murder on one of your victims. What do you guys want me to do about it? So there was a bunch of back and forth, and then the judge ultimately decided that this was a non-fatal error because there was more than enough evidence that was presented during trial to conclude that, nah, this guy was definitely guilty of murder that may have occurred or should have occurred on September 22nd, 2019. So no harm, no foul. They're going to move on to the defense side. Going to be a ton of fun. That was an interesting exercise. If you guys are interested, go check out that video. That's all I had to say. I am so pleased and honored to be surrounded by such interesting and brilliant legal minds. Everybody go check out everybody on this panel.
Who are you talking about?
Yeah, I don't know what you're talking about.
What other shows? What other show are you on?
Yeah,
Hey, listen, I've got to
Steve,
punch
you're
out. I know you
Yeah,
guys will keep talking.
Before you go, I just want to ask you one question, Phil.
Me?
Okay, yeah, you.
Oh,
I want to
okay.
ask you one question because you expressed an opinion about Costello testifying, and I echoed it, and I said, that if they don't, they need a CYA letter. But then I've been hearing so many reports from people who actually watched it, who described, and this is Jesse Waters' report, even Cooper Anderson, like they basically looked as if he was destroyed
Yeah.
but on cross-examination in ways that we outside are not really aware of. Strategically, as a litigator, I want to ask you this. We all think Costello should come in there. That was the first thought I had. But I actually can see where if the last thing we have in this trial as from a fact witness is Michael Cohen, who's obviously the star witness. He was pumped up from the outset, as even before he gets up there, we're going to put our case together, which they didn't. And then he gets up there and he gets utterly destroyed. Is it not sometimes strategically advantageous to say, look, I can have someone else come in here and walk the jury through how he was destroyed, or I could leave that with their flavor as to how crappy the prosecution's case is. And that's why I don't want to risk that I'm going to put my guy up there and then he's going to spend a day and a half being cross-examined by the state and remove that sting, lessen it, that'll be more forgotten by the time they go in for deliberations. So strategically, is it possible that if that's if that's the zeitgeist of the courtroom, that it would make, in your opinion, make sense to say, yeah, look, Costello can add a lot of great things, but perhaps that takes away from our defense just because we're not finishing with that sting. I want to get your thoughts on that because you weighed in on that.
It's almost like it's fourth and short inside the 5. Do you risk it or do you go ahead and take the points? It's a judgment call, and it's something that obviously his lawyers who are in that courtroom and they got a better feel for what's going on. They're going to have to make it. Now, my sense is that you're going to have some redirect of Cohen. They're going to rehabilitate him if they can. They're going to try. And we also may hear from the defense side, we may hear from like an accounting type person, which you'd think that the prosecutor in an accounting fraud case would be bringing in accountants, but no, we got porn stars and ex-lawyers, convicts and whatnot. But they may have something a little bit dry, like accounting. And so if you can leave the jury with the last witness will be this. Look, Costello they're not going to be able to lay a hand on him on cross-examination. He's been practicing law 51 years. He's got his stuff together and he's bringing receipts. He's got it all, and you can corroborate everything he says, unlike Michael Cohen. I would be strongly inclined to put the man up. I might make it as brief as possible. We don't want to get into everything with him, but I would have him tell this jury that Michael Cohen lied to them, and here's proof. That's what I would do, and because I would not want to leave anything left to chance.
This is really interesting because it might be interesting for viewers to see how lawyers think about trial strategy. I mean, I do a lot of advocacy training for barristers, actually around the world. God knows why. I think it's just because I'm happy to.
All you got to do is have them watch this show, though. That's all they need.
No, but I always say to people, I say fundamentally, and especially when you're doing jury advocacy, I say fundamentally, lawyers are storytellers. We are trying to sell a narrative, and we have all the same issues that George Lucas has or anybody else telling a story. We have to make it compelling. We have to make it interesting. It has to have an arc. It has to have a narrative. We have to, and the key thing is it can't have any plot holes. If your case theory requires the jury to do mental gymnastics as opposed to just going, oh God, yeah, that's obvious. That just makes sense. And one thing we address with people in the exercises is we'll have something like some bad character evidence. And it's how do you deal with that? Do you bring it out right at the front and get out of the way? Do you wait till the prosecution raise it and then rebut it? And I'm a big fan of grasp the nettle. Don't try to defend the indefensible. Don't try to argue things that just go against common sense. And I must confess, in this particular case, I would have started with now, Mr. Cohen, it's fair to say, you have been, in the past, your relationship with the truth has been a little bit friends with benefits rather than committed, hasn't it? So,
and that's what the prosecution did. The prosecution tried getting in front. They tried getting in front of all the massive holes in Cohen's credibility that they knew would inevitably come. And
that's what you have to do. But you want to end on your strongest point. And if they can pull Costello, and like you said, I'm a big fan of minimalist advocacy as well. I think the quicker you can do it, 3 points maximum, 2's better than, and 1 point advocacy I'm a big fan of. The one question cross-examination and the one, this is our key ground, because that's all you need to consider. And I would just stick him there and maybe ask him 3 questions and say, by way of example, bang, 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 and then sit down. If they want to cross-examine and give him a chance just to expand on that, well, fantastic. That's their own fault. So just in terms of trial strategy, from what little I have seen of this, and it is difficult because, as you say, I wouldn't have time to watch it in real time anyway, but just reading the news reports and the commentaries, it's through a filter. And it's very hard to know how the jury are reading that. But it does seem they've done a very clever trial strategy, which is to go, yeah, we've got a slippery witness, but we can actually use this ourselves to say, yeah, of course you're a liar, because you were at the time in an organization where lying was just, part of the rigor. And he said, yeah, of course I lied for my client. That's what I did. I'm a dodgy lawyer.
That's why the defense spent some time.
Alan, can I throw you a curveball here?
Please do.
I got this question because of the expertise you're sharing. And the question is from the United States. When you are doing actual advocacy in trial, do you have to wear the outfit that we see traditionally?
In a lot of cases, we do. Now, what's interesting is when I moved down to the Southwest, they're really expensive, and also they're more for me because being the annoying vegan that I am, I can't wear the horse hair, so I have to have a hemp wig, which they're about 600 or 700 quid. My first wig I bought secondhand off some retired old barrister, so it was already, it'd been through 97 hands. And the good thing about it is because I came to the bar a bit late and looked a bit older anyway, sticking on a wig that was clearly ragged, people just assumed I'd been doing it for years. Because actually, interestingly, white wig is an insult here, and there's an appeal that was allowed because a judge referred to a barrister as a white wig. In other words, you're a newbie, and that was considered to undermine them in the eyes of the jury. But yes, we generally do, in a lot of cases, have to robe up. But when I moved to the Southwest, I sort of robed up all properly, and I was waiting outside, and the usher just came out and said, oh, we don't bother with that. And our local top judge, who's actually now moved, he's one of London's top judges, I was just said this. I said, oh, sorry, I robe. He said, yeah, but if you robe up, I have to robe up, and I don't want to. And that was the best and the clearest indication. That's the clearest a judge has ever spoken to me and explained their decision. But I had to do one recently. I had one of my rare outings in court recently. Because, I do a lot of defamation. So obviously our entire strategy is not going to court. If we're in court, something has gone wrong. But I had to robe up for a 5-minute hearing. But luckily we did it by video link. So I believe you call it Donald ducking. We call it Winnie the Poohing. In other words, from there above, I was all robed and proper man's on and the robe and everything. And down underneath it, I was just in my sort of my trousers I'd wear on the beach.
You can use an Instagram cat filter here. That's also acceptable.
That's correct. let me get Ian inside here, because Ian's been trying to make a point for a little while.
Yeah, I just wanted to ask one thing. I didn't want to veer off into the different types of advocacy, but I just want to say, guys, having read the press accounts, having been there, do you have any worry about jury nullification in this particular case against Trump? Is this talk about credibility of Michael Cohen all for naught? It's really less about the actual evidence presented and more about the fact that a prosecution has been mounted against Donald Trump. And at the end of the day, there's just going to be a conviction.
I think we all are looking at. I'm going to say I think people are looking at it from a particular political lens and not looking at the overall case. Because I do agree, Cohen's an absolute liar and all that stuff, and he's got absolute. But looking at the case, the prosecution does have a case. You have David Pecker, you have other people who have testified who don't have those credibility issues. And what the prosecution is trying to do is, we've been saying he's a star witness, but he's really a corroborating witness, right? Because Michael Pecker is the one that says, hey, we have these documents. This is what the plan was. This is what it is. Then you have the people who got the money, Stormy Daniels and the other woman. Here, we got the money. This is why we got the money, because we were going to tell our story and we're sold. And Michael Cohen was the facilitator. So he's essentially, I don't have to believe Cohen totally because I have all these other things. So I'm assuming the prosecution has to put Cohen on because he's material to the whole thing. But I also think the prosecution is going to in that closing, is going to say, hey, he's an absolute liar. You don't got to believe everything he says, but believe the documents, believe Michael Pecker, believe this, believe this, believe this. And that's where I think they'll roll it up to. But now, don't get me wrong. I do think this prosecution is all BS. But I think if you pull back and look at the whole thing, it's not a cakewalk on either side.
Well, David Pecker made the point that tons of celebrities pay off headaches for PR. And not just that, but that Donald Trump himself was paying off for headaches for PR 5 years, 8 years, 10 years before he ever ran for election. So we know that's what he does. He worries about his PR. The notion that the only reason he did this was for his election is, in that lens, somewhat preposterous. Because I'll tell you right now, if he never decided to run for president in 2016, he would have paid Stormy. If he saw this coming down the pike. I think everyone of us recognized that. How do we know that? Well, that's what he was doing in 2011. And that's what Michael Cohen and David Pecker have both said. Yeah, that's what he always did. He would always, if there was a headache, he would kill the story because people are worried about their PR. And that's why I think this entire notion that this is done for election purposes is asinine. David Pecker himself, the guy you're saying, rely on David Pecker. You rely on David Pecker. David Pecker told you that this is what Donald Trump has been doing his entire life, that he basically would kill stories. So
I'm agreeing. I want to make very clear, Joe. Joe, I agree with you 110%. But what you're arguing are facts that a jury needs to determine whether this was for that or whether this was for this. And those facts are what they're putting in front of the jury. Okay,
but no one else knows. No one besides Michael. But here's what I'm saying: no one else but Michael Cohen would know why he paid this woman. No one else knows that.
Yeah. Well, Pecker would, because Pecker had to sign the kill deal, the cash and kill deal, right? So if Pecker knows why he paid one of them.
If I could just ask, gentlemen, your expertise in terms of how the charge is framed. Is it like a sort of strict liability offence? If you pay somebody off during the course of an election, then it's an election offence, or is it a defence to say, no, this is just our standard reputation management? That is motive relevant in terms of the
I'll explain. It's a great question. If you want to jump in on that, you can answer that, Nate.
But before, I want to make the case actually is about business records, right?
Yeah, falsifying business records.
So generally, all of these charges would be misdemeanors because it would essentially we'd say, well, my business record is saying I paid Cohen for legal services, $150,000, but I really paid him to pay off for a hooker. That's a misdemeanor. But they're saying, well, that misdemeanor, we're enhancing it to a felony because his true motive was a campaign finance violation. Now, I know what Joe's going to say because he'll be 110% right, and I agree with him 110%. The federal government rejected that argument. The feds and the election commission said, even though you may be making this argument, he does this all the time. So we're not prosecuting him for that election violation. The good people in the state of New York said, well, we believe it is an election violation, so we're going to up it to a felony instead of a misdemeanor. So now the thing that makes Cohen's testimony is Cohen is saying, well, hey, we really did it for the election. Now, what Joe is saying, which is correct, and I know he's going to kill me with this, is that Pecker's testimony is like, no, we've been doing this for years. So this is not. So the issue at trial now is whether Trump was doing it because he was trying to hide it to be president, or whether he was doing it because that's the felony, or whether he was doing it because he always did it. That would be the misdemeanor. And if he gets the misdemeanor, then all this essentially goes away. If he get the felony, that's the issue. And Joe's right. Pecker's testimony, I don't think helped on that issue because he's been saying we've been doing this for 11 years. So obviously this was just standard operating procedure. Did that explain it? Or
you did a great job, I think, explaining it. And Alan's want to ask the question, but he seems to be nodding in agreement. I also want to point out, Alan raised the question as far as, well, maybe the fact that he's a liar is because he's in the Trump organization, and that's what you have to do to protect this nefarious fellow. And that type of argument, realistically, while MAGA may sit there saying that's asinine, he's talking to a New York audience, and New York has been poisoned against Donald Trump over the last 8 years. So perhaps that would resonate with them. That's why one of the critical things that came out on Cross is that they got him to admit perjuring himself in situations that had nothing to do with Donald Trump. So that is a very telling blow on his credibility. It's not that he was lying for Trump. No, he's just a friggin' liar. That's what he does. He's totally comfortable lying under oath, whether it's for Trump or whatever his interest is. And they basically elicited the reason you did that is because that was for your personal benefit. Was that not why you lied? And he said, yes. And they said, and you convicting Donald Trump is in your personal interest. Is that not true? And he said, yes. So what they basically established is this is a guy who's totally happy, completely lying under oath for his personal benefit, irrespective of whether his personal benefit is for himself individually or who at the time was his idol, Donald Trump, when he was working for the Trump organization. That's just what this guy does. And that's one of the things I think that the defense did, and specifically Todd Blanche did a great job of eliciting that. And I just want to announce to the audience, tomorrow evening, I'm going to have Southern Law in there. In his reading, I'm expecting to give him the part of Michael Cohen to read, unless he prefer to play Todd Blanche. I'll give him the choice.
Michael Cohen, you're gonna make him get destroyed.
Or if he prefers, he can be Todd Blanche, and I'll play the punching bag of Michael Cohen.
Yeah, I'll take Cohen and I'll be glad to take the hit.
But I do want the audience to really understand.
I'm worried you're too sympathetic looking, though. I'm sorry. Go ahead.
No, I don't want the audience. I do want to, because I made a statement earlier, so I don't want to confuse the audience. Cohen is, I don't think he's important to the entire prosecution in terms of misdemeanors, but he is the key point why they need Cohen and why Cohen's testimony is key is because they can't make the felony charges because Cohen is the only person saying this was solely for the election. So Cohen's testimony, that's why he had the recording. So Cohen's testimony is critical to attach it to the felony, for them to make the felony case. But I don't think it's key to make the misdemeanor cases because that's just all paperwork. Was it a legal expense or not? So that's why Cohen's testimony. And I think if the defense, which they're doing, can knock that part down, then I think Trump is essentially free. And that's why they need to say Cohen's just lying about everything. Because if it's that muddy, then obviously tie should go to the defendant.
Do you think that the jury might just do a compromise verdict and just convict on the misdemeanors?
Well, that's a win for Trump, though. If that's no jail time. That's a big win for Trump if they convict on the misdemeanors.
Yeah,
go ahead.
So I didn't mean to interrupt there because this is the other thing you see because more and more now. In trials, the trial is relatively unimportant. It's the public opinion thing. It's like we no longer do defamation, we do reputation management, and this is the whole thing. We talk about strategic litigation. Criminal trials can be strategic litigation, and even though I've no doubt that Trump did not want this to happen, there will be a PR element as to we can milk this, and so long as you do not go to prison. To be honest, I think even if he were to go to prison, I don't think that would necessarily hurt him in an election with the hardcore base. But presumably, you'll have the lawyers looking at the legal strategy, and then you'll have the PR people looking. And sometimes there is a tension there. This is something that crops up over here, where I have to say to clients, because I do a lot of the animal rights stuff, and there are wider issues. And I say to people, my job is to win the case. And sometimes that might mean to win the case, either not calling you as a witness or, saying, actually, this person is terrible or got everything wrong or said all the wrong things. However, they are not liable as a matter of law or things like that. And that is the huge tension with your client, isn't it? And I'm sure every lawyer here has that question that you say to a new client. What are you seeking to achieve? And they might say, well, I want to win the case. And you go, well, actually, do you? Or do you want to have the trial on your own terms and say what you want to say? Because sometimes they are very, very different things.
And I'm sure you've seen, Alan, you'll come across very different kinds of clients depending on the nature of their personality. From what we've seen of Donald Trump, would you not agree with me that he's not someone who heeds direction of, he's not someone who's likely to heed direction of counsel very, very easily. That you might tell him, don't tweet, and he's going to do, Donald Trump's going to do what Donald Trump wants to do. If he wants to testify, his lawyers will never talk him off of that bridge. And if he doesn't want to testify, which it's hard to imagine that he won't want to testify. I mean, his lawyers may sit there hounding him saying, no. But at the end of the day, this is one of those instances where most of the time clients will just do what the attorney tells them. And I think at least 8, if not 9 out of 10 situations, they're going to do what we tell them. Donald Trump's particular personality is exactly the type of someone who will basically say, I know better than you. I'm doing what I want to do here. I understand PR. I understand marketing. I understand how to sell this to the jury. I want to get up there and do this.
Well, this is interesting because you see that the problem is, especially with witnesses who think they're smarter than they are, especially witnesses who are used to commanding an audience, and then suddenly being put in a courtroom where the rules are different. They have to shut up. They have to answer questions. They have to take their turn. They can't talk over people. I saw, this goes back actually to the idea of, your clients. There was a famous case here, Irving and Lipstadt, where David Irving, an historian, he sued for being accused for being a Holocaust denier. And the interesting thing, Deborah Lipstadt, who'd written the book, she wanted to give evidence. And the legal team said, no, because if you give evidence, we'll lose. We don't need you. We can win this case without you. And we've got more chance of winning this case without you. And apparently she was like, well, I know I want to. Yeah, I have been accused of this. I need to. It's like, no, you don't. Because apparently, if we lose this case, every Holocaust denier in the world is going to be saying English court finds Holocaust was a hoax. So we can't take that risk. If you want us to take this case on, I mean, we can't pick or choose clients. We have that cab rank thing. But we do have it's entirely up to us which witnesses we call and what evidence we do. We can't force a client to give evidence, but we can refuse to call them. And there's no comeback on that unless they want to sack us. We can say, no, I'm not calling you.
But this is a question. Do you guys have because there's a distinction here between a criminal case versus a civil case. In civil cases, yes, but in criminal cases, the defendant here has the right to testify. So if they say I want to testify, then your hands are pretty much tied.
Well, in practice, if a client wanted, unlike American criminal trials, defendants here nearly always give evidence because although we have the right to silence, which you can exercise at any stage when you're being arrested, when you're being interviewed, and indeed in court, juries are allowed to draw such adverse inferences as they see proper. In other words, you can't convict. You're not allowed. They're told they can't.
That's not a right to silence. That's not a right to silence.
Well, we've been having this argument, Joe, since 1994. So afterwards, if you ever make it over here, we'll meet up for a beer somewhere and we can rehash this.
We'll grab a pint, will we?
Right, we will grab a pint. We'll grab a pint of warm beer. Proper beer with a head on it of a decent alcohol percentage. None of this sort of 3% all made in a chemical vat in Milwaukee.
Oh, that I'm down for. I'm down for a heavier beer. That's for sure.
Yeah, but I think this is interesting. I think your viewership might find the contrast there between the English approach and the American approach very different. Where, generally speaking, if you're not putting your client in the box to give evidence, you're pretty much conceding you don't have a defense. That is how it is seen here. But like I say, theoretically, barristers have absolute discretion over how we run a case. It's not up to the client.
See, and here in the United States, though, it's the exact opposite. If the defendant says, I don't want to testify, no negative inference can be inferred from that action because they have the right not to testify. And if the jury finds that, hey, because he didn't testify, we didn't hear from him, we're gonna that would be reversible error.
Well, the American approach, it seems to be that by calling your own witness, you're conceding that the prosecution have actually established a prima facie case. I mean, it's
the
such a different culture.
The judge will give the judge always gives jury instructions before the jury goes out for deliberations.
Yeah.
And there'll be a long series of how they're supposed to fill out the forms and what findings of fact they need to make in order to reach their conclusions. And if it's a criminal case and the defendant chooses not to testify, they're required to basically explain to the jury and direct them that they are to take no negative inference whatsoever from the fact that he refused to testify and didn't speak up in his own defense. That's actually a requirement that in every criminal courtroom across the country.
If you don't get it, matter of fact, that's reversible error. If the
it is reversible error, yeah.
And then they will take a negative inference one way or the other, depending on whether they like the guy, as he said, in the courtroom.
That was the rule. That was exactly the direction here prior to 1994. Now, obviously, Twitter at the moment with the Lucy Belleffi case is all about how unfair and evil the English system is. But it's very, very interesting that and just to give you an example, when it comes to the defense case, the judge says to the defendant in front of the jury, and they say, right, now, Mr. Defendant, it is now your opportunity to give evidence. It's entirely up to you if you do give evidence or not. If you do not, however, the jury will be told that they can draw inferences. Now, having been told all that, do you still wish to give evidence? So there's like a little public ritual where you are sort of put on the spot as the defendant as to, here's your chance to explain everything to the jury. And if you don't take it now, you can't blame them. You can't blame anybody if they assume you're guilty.
See, and that's a key distinction between American law, because in American law, the defendant has to prove nothing. The defendant can go up there and say, I'm not putting on a stitch of evidence. I'm not calling the client. And then when it goes to the jury, the judge will say, it's not up to them to prove a damn thing. It's all up to the prosecution didn't prove their case, and you got to go back there with the defendant with the presumption of innocence. So even after the trial, you got the defendant is presumed innocent, and you can't use the fact that he didn't put any evidence on against him. The prosecution has to prove its case.
And that is the theory here, but the failure to give an account is evidence. The only rule, the only direction about that is that you cannot convict solely on the basis that somebody exercises their right to silence. There must be other corroborative evidence as well. But yeah, that is a major, major distinction. And you can imagine how controversial that was. I mean, that's 30 years ago that came out. I remember going to the demos. Well, I say demos, they're actually big, like, free music festivals. So I was there for the politics and definitely not the falafel.
And that's a key distinction I wanted to say about this case. You know, I talked a little bit about kind of pessimism with respect to jury nullification. But, you know, if you actually go to the statute that's applicable to this particular case, we're looking at an element. A person is guilty of falsifying business records in the second degree with an intent to defraud. And I got to say, that actual component could be something that, one, no testimony by Trump would be valuable, because there would be no offering of any sort of, confusion relating intent to defraud. Frankly, I think these records could have been named the way they were named with no intent to defraud. Who in the world wants to say paid Stormy Daniels to try to avoid having a sexual story? You're not going to do that. And then more importantly, if this case went up on appeal, that's an insufficiency of the evidence issue. So even if the jury goes forward and says, we hate Trump, so we're going to convict him. Even if Trump goes on the stand and says, I don't even know what's going on here, but I would never The point of it is there's not going to be enough evidence to say intent to defraud in order to convict Trump, even of a misdemeanor. So I do think that if this case, if you're going to analyze it technically, I hope they keep Trump off the stand, because that's the key component of this statute.
Yeah. Yeah, I think that's a great point. By the way, addressing something Alan was raising earlier about distinctions between American law and English law. You were saying how they publicly will make a statement about whether or not they're testifying and be put on in front of full view of everyone. We don't have that. The jury does not hear. There is a moment. It has to be gotten on the record. If the defendant chooses not to take the stand, so he has to be questioned, voir dire directly by the judge to the defendant, asking him whether he wishes to take the stand. If he wishes not to take the stand, in that case, that the jury will be directed to take no inference from that. and that he has to make that choice of his own volition, not pressured into it by his lawyers or anything of that nature when he chooses. And this is something Trump will be asked if he chooses not to testify, that he's going to have to go on the record and say that I voluntarily, my own volition, chose not to testify. But the jury will not hear that. The jury will not see that whole back and forth exchange, as opposed to what you were saying is it's done in full public view, which I assume means that the jury sees him answering, making that determination then and there, which only makes it that much worse. That obviously you have to testify because now the jury hears the defense. Think about what's happening in this British system and why I think this is so terrible. The jury hears
English system.
Oh yeah. Thank you. Yeah, that fine. The English system is the one that sucks, not the British one. So, and this is why I think that, because now the jury gets to hear the judge tell this defendant that if you don't take the stand, I'm going to tell this jury they can use that as a basis to draw an inference against you, to draw negative inferences against you. And the guy still says, nope, I'm not taking the stand. How the hell can you not take the stand if you're in the English system? You have to take the stand. And that means that there essentially is no right to remain silent. There's a right to remain silent. Yeah, they can't force you to start talking, but it's just so it's practically malpractice.
It's
to
a right
remain
with
silent.
consequences.
That obviously was the point that was made at the time, and it's the same with police interviews. The caution here is, our Miranda rights are. You have the right to remain silent. However, it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. So there is, even at the caution stage, you know that. But just to go into like little quirky across the pond things, of course, I was very careful to distinguish between Scottish law and English and Welsh law there, because the great thing about Scotland, of course, is they have 3 verdicts. They have not guilty, not guilty, and not proven. Not proven generally being, okay, you're innocent, now don't do it again.
Yeah, I think at the end of the day, the difference, we're all talking about the same thing, but I think in the Trump trial particularly, I agree with Ian and Joe, is that there's no way I would put Trump on the stand, because I don't think they can prove their case without Trump being on the stand, because how do you improve his intent, especially if you do have the fact that he's been doing this for the past 10,
and especially a
15
guy who for the last 8 years, if he says something aggressive, they take it as being aggressive, and if he says something the opposite of being aggressive, they assume he's being sarcastic. So if that's what the audience you're dealing with here, no matter what he says or how he says it, they're going to take it and how they're going to take it. That's the Trump-Rorschach test that we saw with the phone call on the first impeachment with Zelensky. As far as, is he having a normal diplomatic conversation, or is he threatening him like a KGB guy? And you're talking to the people who are going to be reading him by and large negatively, and accordingly, no matter how he expresses himself, they have been already well trained to take his words and as either being, when he says march peacefully and patriotically, that's a dog whistle telling them to attack go grab the pitchforks and find Pence. So yeah, how is it that he could possibly get up there and help his case rather than harm his case?
Steve, Southern Law, what are your predictions on this whole Trump case? Because
I kind of split the baby there a little bit, that I don't know that I believe that the jury cares a lot, that they're going to decide this on other things, and putting Trump up there, I don't think that would save him, but it would possibly expose him. So I wouldn't want to put him up there either. I'm afraid whether people will really understand what you have to have, Nate, that you really explained really well, the steps they have to take to actually establish this case to a felony level, or whatever it takes to get past statute of limitations. In other words, the false record plus. I think it's just in the ether there. Everybody watching the case, if they like Trump, they're like, he didn't do anything. I don't need to see any evidence. He didn't do anything. And then other people will think he did it. Whatever it is, he did it, because he's got to go to jail, right? He has to go to jail. So I wouldn't put him on either for those reasons. I think if the state has not made its case, he's okay. If the state has made its case, this is just a risk for Trump to get up there and testify for all the reasons Joe's talking about. They're going to construe anything he says against him.
Would you put him on, Ian?
No, I would not put him on. I think that Trump is going to be convicted of misdemeanors. I think it's going to be appealed at some point in time. I think it's not going to impact his his presidential run, other than the fact that now he's able to advertise that they ramrodded me
convicted him on the misdemeanors.
I'm feeling screwed. Yeah.
34 misdemeanors. We got him on 34 misdemeanors.
Yeah. He was talking the other day about Al Capone and comparing himself to Al Capone. I think it's almost like he's going to wear it as a badge of honor and saying, "Man, I did it. I came through this, and I'm here for you. Truly, I don't care about going through a trial." Blah 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 blah. So I almost think that it works out either way for Trump.
I think that's a good, because just doing somebody on what effectively a regulatory offences, especially ones where, as Joe's saying, if you'd have just called that column miscellaneous expenses or PR expenses or something like that, then that would have been the end of it. And I think making the point that it's merely because of the label, and so many people, and I think this might cross party lines, so many people will have had brushes with officialdom where they've got fines or something like that for just ticking the wrong box. I think there'll be a lot of sympathy there that you've just broken a butterfly on a wheel. I hate to compare Trump. I'm not sure that's the best comparison, but
no, Donald Trump is a beautiful butterfly. Okay,
he's broken on the wheel.
Crushed on a wheel. He's being crushed on the wheel of New York's judicial system right now. I think that's the perfect analogy there, Alan.
Okay. I do want to ask you guys before we get out of here. So the appeal for Trump's other liable case against the one that he has to pay $83 million for E. Jean Carroll. Now their core argument in their appeal is simple. Now, for those of you who don't know, the jury in the Trump E. Jean Carroll case found Trump not to be liable for grape, but and to only be liable for for illicit sexual contact. In other words, you slap somebody's butt, but not grape. So in the defamation piece of it, Trump said, "Well, I didn't grape her." The judge, so that's what E. Jean Carroll sued Trump for defamation, because she said, "No, you did grape me," and the jury, and this was proven. So Trump's argument to that thing was like, "Listen, I have a jury that specifically said I didn't grape you." The judge then says, "Well, I'm going to side with Carroll and say, even though the jury said you didn't grape her by a preponderance of the evidence, I believe that the jury got it wrong, because the jury was understanding it in the legal context of what grape means and not the colloquial context of what grape means. So grape in a colloquial context, what you did qualifies as grape." And then he's making Trump pay $83 million. So I'm asking you guys, what do you guys think? I'll start with Steve, Southern Law. Steve, what do you think about Trump's appeal possibility? Well, what do you think about his chances of an appeal, given his argument that, hey, I have a jury who said I didn't grape her under the lower standard of preponderance of the evidence, and the judge is finding finding me liable for defamation for saying what the jury found?
Well, I did, whatever you may think of what Trump said or didn't say, the fact that the judge said, "Well, I'm just going to consider it that," when the jury found the precise opposite. I thought it was ridiculous. I thought that was that whole case, the damage amount, and that element you're talking about with the judge saying, "Well, I'm still going to call it that." That should be overturned. Whether it will be, it's I don't know the courts up there, but I didn't like that at all. I just think that's ridiculous. They're just ways to get him.
Well, don't forget they just did that for Harvey Weinstein. Everybody thought Harvey Weinstein was going down, and they just overturned it because they were like, "Well, you went too far." So I think Trump has some help, because don't forget, if they allow this to happen, then what about all those other cases? Joe, let me throw it to you. What do you think?
Which cases?
The case of Trump's appeal. What do you think his chances are appeal?
There's always a way to distinguish Trump. There's always a way to distinguish Trump. And that's what we've seen here. No, Trump is different. Trump is completely different from everyone else. That's what they're going to try. That's what I think and I think in their hearts and minds, and I can't stress this enough. I cannot stress this enough to your audience here, who is likely, moderately to strongly right-leaning. The mentality here in New York is not that they're being evil, not that they're being, unfair, that everything they're doing here is to save America. That's how they're looking at this. They look as if they're genuinely the good guys, and that you and I, who are either evil or more likely hoodwinked by this phenomenal comment, because we're too stupid to see through to see through all of his his cons, that so that they can bend the rules, break the rules, pretend the rules don't exist, or for one reason or another they're not bending and breaking the rules. And even though in their hearts and minds they know that they're bending and breaking the rules, I think that there's a rationalization that goes on in their own hearts and minds where they're like, no, this is necessary. This is something that must be done to save democracy, even though we don't live in a democracy. But that's how they look at it, that they are the good guys here, and it's for our own good that they have to pretend that these rules don't apply. And whatever way, and once you start with that mindset, anything that you're doing is easily justifiable. So and that's what makes it so frustrating is, when you're talking to people who have that mindset, that they feel that they're actually acting virtuously and that they're actually helping society. And you're basically, to them, you are arguing for Adolf. That's what you're doing. You're arguing to try and enable and empower and embolden and strengthen Adolf and his moronic followers who are marching behind them. And if you were in 1938 Germany, and what would you do to try and stop that? And that's really how they look at it. I think they're deluded beyond comprehension, but that is how their minds have been poisoned at this point. I mean, Nate, you're from New York. Do you think anything I just said about the New York mentality here is a misstatement as far as how the elitists look? I think that the black community is starting to march toward Trump because what Alan raised about that point about how those people who have dealt with brushes of the law can recognize when someone's being railroaded. And I think that members of the jury who are like that definitely can feel that that's what is happening here. And I think go ahead.
Well, just to answer your question, I think Trump is a case study in how politics changes people's hearts. Because for those of you who don't know, Trump was the biggest supporter of BLM. He was marching in the streets with Al Sharpton. This is not something I'm not, Jesse Jackson. There's cameras and pictures and all that. This is not something I'm making up. This is something. Matter of fact, Trump was the main and not antagonist. He was the main person in rap and a lot of rap songs and stuff. I got money like Trump, all that crap. So Trump was very much ingratiated into the left wing, and he says it. Trump. This is not. I'm not telling anybody anything they don't know. It's kind of like Ronald Reagan before he became conservative and after, and Trump even says it. But to see how someone who was giving money to the National Action Network, who was thought to be this great person for the left, all of it was on Oprah, right? Oprah, I'll run as a Republican because they're dumb. Soon as he says I'm running as a Republican, he became racist. He became this. He became this. He became this. Now, I think the issue is that everybody, I think, is now starting to realize at this point in time that, hey, this guy who you say is the racist is all that. Guess what? When he was president, black unemployment was the lowest it's ever been in the country's history. He was giving, during this. So it's like, even though you're telling us this, it's not this. And now you're going into, now you're treating him like many of us have been saying we treated. Because if you think about the Black Lives Matter movement, it was like, you're treating us unfairly. You're making these things up. You're going above and beyond to get me for stuff that other people do. And now Trump is coming in and the same thing is happening with him. What are you talking about? Everybody's doing this thing, paying this thing up, but let's prosecute him. Everybody, when Hillary Clinton said the election was stolen, nobody prosecuted her. Now he's got 5 indictments for it. What's going on? So using the system or the thought of the system being used to stop someone because you don't like who they are, that's what I think resonates with the black and brown communities. And I think the leftists don't understand that because they think it's only about skin color. But it's not. It's about how the system is treating this guy. That's why now you see Trump, so everybody understands the polls. Trump has got the highest, he's polling higher than any other Republican in the black community in the past 50 years. That's
Nate,
crazy.
I just want to add, it's one thing to be prosecuted and feel that. I've been prosecuted and I feel that, and I feel like with Trump, but it's also when they open the box of worms, when they open the trial, when there's reports and it's all kind of BS and like made up, it makes it even more strong. I think the coffin was sealed when these prosecutions were released. I really do, because the cases are horrible. Again, not even trying to be partisan about it. If you just look at these cases and the evidence that's been brought, when people actually open that door, they go, and really, we're spending millions of our taxpayer dollars on this, and that makes us just want to vote for Trump even more.
Yeah, because he checked the wrong box, so he's got to do felonies. Go ahead,
Yep.
Alex.
I want to hear Nate's rap song, because I want to hear somebody say, "I got money like Trump. It's mainly tied up. It's not in liquid at the moment. Quite a lot of it's in trusts."
I gotta find because I can't play because it's copyrighted. I don't want to get copyright struck. But these guys.
It's not our channel.
Yeah.
But am I lying for those guys from the U.S.? Am I lying? No, I can find a picture of him with the National Action Network and stuff like that. So,
I think what Alan's saying is it's not LL Cool J, it's LLC Cool J.
It's LL. Quite a lot of it's tied up in. It's tied up in property. But interestingly, we had the same thing here with Boris Johnson. Boris Johnson was an absolute Europhile. He did one of the best documentaries on why Britain's place is in Europe. He was left-leaning. He was completely, like myself, very SJW and woke. But he saw an opportunity to get into Downing Street, number 10, by latching onto a particular cause that everybody knows he didn't believe in. But he managed to do the "I'll get Brexit done." Then, of course, I think a little bit like Trump, he found out that actually getting the job is quite hard. It's not all just going to soirees and meeting foreign diplomats. You've actually got to do some work. And that's why Johnson didn't last very long in the job. But yeah, I mean, it's an interesting thing because obviously Trump is your classic polarizing figure. But I think the problem here is, the trouble with Trump is you've got all the Central Park 5 stuff, but then you've got all the fact that he hangs around. And I think what people forget is, especially at that level of politics, there is a little bit of everything in it together. The fact that Melania, is best friends with George Bush. Sorry, not Melania. Michelle is best friends with George Bush and says, he's my homie and things like that. And I think partly when people are out of politics, they're allowed to be themselves again. You get loads of politicians here who, once they're actually out of politics, it's like, well, look, I was just towing the party line. This is what I really think. And I think you've got a lot of that over there. But I think this is the danger of over-prosecuting. Yes, it's a technical affair. And I don't think people should be treated differently, either more robustly or less robustly, just because they're famous or not. If this is a case where they would have prosecuted anybody in the same situation, well, yeah, fine. But will they be able to show that? What normally happens when people make mistakes on, filing their accounts or filing their regulatory paperwork?
I got to stop you right here. I don't think anybody in America believes if this was somebody other than the words of Trump, they would be prosecuted under these things. Matter of fact, soon as the Justice Department said, we don't see a campaign violation, there's no way any one of us regular people are getting charged with felonies. Right, because the people who prosecute this particular crime said we don't believe there's a crime, but New York says we disagree. We believe it's a federal crime, so we're going to prosecute him under this theory. That's the issue here,
and that's the trouble. You look like you're too gung. We'll know here that when you litigate in anything, you only fight the battles you can win. We've all read Sun Tzu or the LinkedIn version of it. And I think this is one where they've picked a fight that perhaps I can understand maybe why they felt compelled to do it. And, and it wouldn't surprise me. They may get a conviction on the felony just because, as you say, a New York jury may well convict. I don't think that'll harm Trump politically at all. I think he can really play into it and do the martyr thing. We've had that. We had to change the law here recently to say you cannot campaign for office from prison because back in the old IRA days, we were electing people who were serving time like life sentences, and they had to say, well, actually, if you're serving a prison sentence, you can't be a member of parliament because people were electing people who were in jail, or sorry, in prison to be technical.
Nate, do you have control here over
Yes. Let's get out of here. I forgot I do have control.
Someone here is going to have to. Hit.
Can you ever shut this off?
Yeah.
I'll be eating dinner, going to bed.
Let's go around. I forgot Eric's not. I don't think Eric's getting back. So let's go around the table. All right. So first, we're going to go around. We'll start with you, Eric. Tell people where they can find you. What your channel? I'm not Eric. I'm saying Alan. If you can if you could put his link in the chat, that would also be great. Go ahead, Alan. Tell people where they can find you.
Well, thank you. And just to say, Nate, I've really enjoyed being on yours and Steve's show tonight. I don't know who that other guy was you had on a guest a bit earlier, Ian somebody. He was all right, wasn't he? But no, but I do a channel called Art of Law, where it's ostensibly an art law channel, but it's usually me rambling inanely about topics that I know nothing about.
Not
in terms
possible.
of expectation management, I've always made it very clear that, you know, I'm just guessing here. But I like to try and get out and about and film in nice places and then talk about the history of the place. So, I mean, if you just want like pictures of all like interesting, like pretty buildings or nice landscapes, watch for that. If you're watching for the legal stuff, I don't know, just check out Joshua Rosenberg or somebody actually competent and clever. But I've really enjoyed this, guys, because and gal, because Danny's gone now, because I am fascinated by comparative jurisprudence, to use the posh word, but also just the difference in culture. And this is something, like I said, I do a lot of advocacy training. And it's really interesting where ostensibly we're all using the common law system. Lots of places they're still doing the wig and gown routine. But even though it's theoretically the same system, the courtroom culture and especially the litigation culture is so different. So it's been absolutely fascinating to hear what everybody's had to say. And I've learned so much from you guys tonight. It's been really, really interesting. So thank you ever so much for putting up with my waffling.
Thank you so much. Thank you so much for being here. And don't if you can put your link in the private chat so I can throw it into the public chat so everybody can find you.
I'll try and do that. I'm not that confident.
But I think for everybody else, Eric has put everyone's link in the description, so make it easy for you guys to find. Don't forget, please click on everybody's channel and go subscribe. Steve, Southern Law, you're up next. Tell people what you've been working on and where they can find you.
So the channel Southern Law, but I have not been posting much lately, and still probably can't for a while. Is I think Alan mentioned earlier, the case you're in the middle of is the one you can't talk about, and I have been to the wall for the last several weeks on some interesting stuff that, but I am nearly smoked. But if I can stay up tomorrow night, I'm looking forward to spending some time with Joe to decompress a little bit and see if I can do a good service for his fine audience. So that's where you'll see me ideally.
And just so everybody knows, this is a link for Joe's Gifts and Go. Joe, you'll explain what the link is about in a couple of seconds. Let me hit Ian up. Ian, please tell us now, just for full disclosure, I still remember Ian Ian was like one of the first lawyers I ever saw on YouTube, and his video actually helped inspire me to do what I do. So I'm actually happy to at least be able to spend the time on a panel with Ian. Ian, please tell people who you are and tell them where they can find you.
Thank you so much, Nate. I really appreciate that. You know, I was trying to think recently about what I do, and I just do important legal explanations, and that's kind of the name of my channel on X, which I'm spending most of my time with right now. I'm really enjoying it because you're able to get much more content out there, not being censored. However, at Ian Corzine on X, on Facebook, on Instagram, on YouTube, on TikTok. You can find me. Basically, what I like to do is give commentary, the legal side of a lot of the important issues that we're facing today. And so I'd love for you to join. And I'm going to be doing more live streams myself because I really enjoy this format. So thank you so much for having me on. Appreciate it.
You're muted. You're muted. We don't.
I'm muted.
Yeah.
See, I'm about to say it, Joe. I'm not going to cut you off. So don't give us the hour rant. But Joe, but please support Joe's cause. Joe is he's trying to do great work and trying to ungag Trump. I want to put the link back up. Please, if you can, please support Joe's efforts, because even if it's not about the win or loss, but it's about at least pushing back and to let people know that we're not going to take it, and you will get some pushback if you do go too far. So I want everyone to please support Joe in his effort. Joe, tell people why they should support you in your effort to ungagging Trump.
Okay. This is not, in 5 years, Donald Trump is not going to be part of our political landscape ever again. Whether he wins or loses, in 5 years, he's history. In 10 years, he's history. In 20 years, he's history. But these precedents that are being set now, where if you're over 20, you probably felt like you grew up where First Amendment rights and your right to freedom of speech was inviolate. These new findings that have been issued against Trump will be used again and again and again, where when the state ramps up its energy against defendants, that they will say this person's free speech is harming the fair administration of justice. And that's the rationale they used here for someone who has an audience not merely of 100 million like Trump has, but 5 million, 2 million, 200,000, 20,000, that they could theoretically inspire folks to by dint of their tweets to do things that would harm the fair administration of justice. Every person you follow and watch or admire their opinion is in jeopardy of having their rights trampled. New York State this week in the Court of Appeals denying our application has sent a message that the chances that we're going to succeed in the state of New York seem relatively slim. Now that we still can win in New York, but if we don't win in New York, I plan on going to the Supreme Court. The costs associated with that are in the tens of thousands. We're looking at least $25,000. That's not legal fees. That's just as far as publishing. That's as far as having someone prepare the writ of certiorari. I do expect that I'm going to be fighting to get into the Supreme Court so that they can stand up for the Supreme Court precedents that have been utterly bastardized by these gag orders. They've been Frankensteined into something completely new. And what the DC Circuit Court said, that is going to stay on the books 10 years, 20 years, 40 years from now, long after Donald Trump is gone. And those precedents must be overturned. I urge you to help me stand with freedom of speech. You can go to givesendgo.com/ungagtrump. And together, hopefully, we can convince the Supreme Court to say that all these rulings, which are stripping away our core fundamental right of freedom of speech, have to be overturned. So there you go.
Thank you so much. Well said. And thank you to all my guests. Please, guys, support. If you support the show, don't forget to support the guests because they give their time and give us this great legal knowledge every week. Now, I know I'm the crazy lefty that everybody hates in the chat, so let me know how much you hate me in the comment section. And don't forget to subscribe to all the great guests here. For Eric Hunley, who I don't know where he disappeared to, and for all the guests, thanks again for watching, and we'll see you in the next one. Peace.
Thank you.